My name is Elena Taylor, and I am the Dallas Area Paralegal Association's Medical/PI and Real Estate Section Chair. I am joined today by Laura Kehoe, our Executive Director, along with Ms. Noelle Hicks, our presenter. We appreciate you taking the time to attend during your lunch hour. Also wanted to remind you to check out our events calendar at dallasparalegals.org for any upcoming CLE, and also to remind you that our next general membership meeting is next week, Tuesday, January 16th. It is an ethics meeting, so please be sure to register to attend, and that is in person. Also, please remember to renew your membership by the end of February for 2024. Today's session will be with today's session, we ask that you hold your questions until the end of the presentation. Also, feel free to post your questions and comments in the chat, and we will monitor those. Towards the end of the CLE, a passcode will be issued, and if we would like to receive a certificate for this presentation, you would send an email to myself, Elena Taylor, and I will input that information in the chat room towards the end of this presentation. Without further ado, I would like to introduce our presenter, Ms. Noelle Hicks. Ms. Hicks.
Thank you, Elena, and good morning. Well, good afternoon, everyone. My name is Noelle Hicks, and I am an attorney out of Houston. I'm a shareholder at Roberts, Markell, Weinberg, Butler, Haley, and the majority of my practice is representing property owners associations as well as other real estate litigation type issues. But today I'm going to talk a little bit to you guys about drafting forms that kind of coincide with changes in the legislature that affect property owners associations. And as you all probably know, every 2 years, there are some changes with, there's a legislative session, and generally there are changes in the legislature that affect property owners associations, which people might not really realize very often because it's not something that everyone thinks about. But you know, Texas is one of the states that has lots of property owners associations. They're coming up every day now. There's new developments popping up every day. So it's important that we kind of, can wrap our minds around the different changes that go on. And of course, here at our firm, we are always, kind of trying to stay up to date, and we're as involved as possible with these legislative updates so that we can make sure that our clients are represented effectively. So I'm going to talk a little bit about the first time I gave this presentation was back in 2022, when we had just come out of the 87th legislative session, and there were a lot of changes that happened. That we recently just came out of another legislative session. It's not completely over with, and so there are some things that I'll talk about that may happen in the future that we're not totally sure about, but the point of this presentation is to make sure that you have documents that make it so that property owners associations can continue to do what they do, which is to self-govern. And of course, the law that I will tell you about today it's not legal advice, but it's just for educational purposes. And it is the law as of today, January 10th, 2024. I can't believe I'm saying 2024, but let's go ahead and get started. So I will talk a little bit about policies that would have come out of Chapter 202 of the Texas Property Code, and then we'll jump into 209 and 82. For the purposes of this presentation, keep in mind Chapter 209 of the Texas Property Code is relevant to single-family communities. Chapter 82 is relevant to condominiums. And then we'll talk a little bit about resale certificates that affect both of these types of communities. I told Elena earlier that this probably won't take the full hour. We'll probably wrap up around 40-45 minutes. And so if there's any questions at the end, I'm happy to address those. So the first major changes that came out of the 87th legislative session relating to Chapter 202 of the Texas Property Code are regulation of religious items, swimming pool enclosures, and security measures. And I'm going to go through each one of these and talk about what the changes were. And then I'll talk about how we would address these in policies or rules and regulations related to each property owners association. So the law related to the regulation of religious items comes out of Chapter 82. It's Chapter 202. It's Section 202.018 of the Texas Property Code. And this one was amended during the 87th legislative session. Now, before the 87th legislative session amended this, which was I muted the whole time? Oh, that's weird.
No, that was my fault. Sorry.
Oh, okay. So previously, a homeowner was permitted to put any sort of religious display or religious item and affix it to the threshold of their property. And the association, a property owners association, wasn't permitted to enforce any rules that would restrict their doing so, right? So they were allowed to put anything on the entry of their home that represented whatever religion that they were involved in or they ascribed to. Well, as of September 1st, 2021, the statute was expanded to include a person displaying or affixing religious items on their dwelling, but not only on their dwelling, but they could also put it just kind of like on their property. And the only way that the association could institute rules to prohibit that was if such a display threatened public health or safety, if it violated some other law, if it contained something that was offensive to a passerby, or if it was placed on property that was owned or maintained by the property owners association. And of course, if it violated any sort of building line, right-of-way setback or easement or anything like that, that was something that the association could control. And then finally, if it was attached to a traffic light or a street lamp or fire hydrant or anything like that, that's something that the association can restrict. But in general, the homeowner is allowed to display a religious item on their property without much restriction. Now, the problem with this is that some people may take this law to the extreme if they know about it. So what we were really concerned about was a person erecting like a 6-foot cross on their property or something like that. And while that's something that might actually display the religion that they ascribe to, it's something that the association should be able to have some sort of power to regulate, right? So with that being said, one of our recommendations was to make sure that the association put some sort of policy in place to still give them the ability to regulate items like this. Now, of course, with any type of policy that I'm going to talk about today and any policy in general, and actually, let me go back a little bit. So the association has the ability to regulate according to what we call a declaration. Their declaration usually sets forth whatever rules, the obligation to pay assessments, things like that, right? But it usually will also give the board of the association the ability to create rules and regulations and enforce those with the authority that's given to them in the declaration. And so one of those things is creating policies that kind of mirror whatever new laws come out or things that are specific to the community that they are trying to regulate certain things in, to make it so that, again, the association keeps that ability to self-regulate. So when rules like this change, it's our responsibility to make sure that the association that we represent has something put in place so that they can maintain this self-regulation or self-governance. So what our recommendation would be is to create a policy. And 9 times out of 10, the association that we represent already had a policy like this, but it needed to be amended, right? So to create a policy that mirrors the language of the statute, but also put certain things in place for the association to regulate. So in addition to, the language of the statute, we would also insert something that says maybe the association would require a homeowner to submit an application to their ACC or their Architectural Control Committee with the specifications of whatever religious item that they're going to put in place. So the ACC could actually review it and not necessarily prohibit them from erecting such a religious display, but to make sure that it didn't violate any of the 6 things that are here on this slide. So that's what a policy would look like, relating to the regulation of certain religious items. And, I'll talk about different policies and things like that, but this is one of the changes that came from the 2021 legislative session. Another one of the changes that came out of that session was an amendment to, or an addition to Chapter 202, and it was the swimming pool enclosures. Now, interestingly, I had a community that I represented back in, it was some time ago, and this was a big issue for them, swimming pool enclosures, because the association had certain rules in place that would not allow the homeowner to put up a certain type of swimming pool enclosure. And one of the main issues that was being raised was, safety, right? So homeowners were trying to make sure that their children or their animals or whatever didn't fall into the pool. So this rule came into play in 2021. And basically, it would allow a homeowner to install a fence that surrounds a pool or a spa or whatever kind of water feature that they have, and that it could be made of transparent mesh or clear panels set in metal frames, but that it couldn't be any higher than 6 feet, and something that was designed to not be climbable so long as it conformed to whatever state or local safety requirements were involved there. So this is actually a really big deal because we want to make sure that homeowners are allowed to, put things in place for safety, but also, to kind of keep in mind the aesthetic and just the general overview of the community, right? So again, with this kind of thing, creating a policy for this to make sure that homeowners can go ahead and still put in those safety measures, but that it's still kept in line with whatever the aesthetic of the community actually is. Now, the association could adopt certain policies, rules, or regulations that provided other limitations to the swimming pool enclosures, but it still needed to make sure that it stayed in line with what the Texas Property Code actually allowed. So this provision didn't actually prohibit a swimming pool enclosure that was black in color, or of course that transparent mesh set in metal frames. But if you can see from the picture here, this is something that would be allowed to that clear or that transparent fencing along the outside perimeter of the swimming pool. And again, this is nice looking, right? But, and this is something that's allowed by the property code, but you want to make sure that it's not higher than 6 feet. It's not something that's climbable, those kind of things. So if we're creating a policy for a property owners association, that's specific to swimming pool enclosures, we want to make sure that it doesn't prevent an owner from installing something like this, but that it's still, it looks nice, it's not a danger to anyone, and it's in compliance with state and local laws. All right, and then finally, and this one is the one that kind of has given us the most headache, it is the security measures policy. And so in 2021, we had an addition to Section 202, which would allow owners to build or install security measures. And so the security measures were cameras, motion detectors, or perimeter fences. Now, I want you to kind of think about what the implications of this policy would have been. And the most problems that we had really were with perimeter fences. Because if you can imagine, most of the time people will put up a security fence, like a wooden picket fence or something like that. And the fence will be, it'll surround maybe the front yard of the property, or maybe the backyard of the property like this. But what this actually meant was that a person could go to their property line and build a fence all the way around their property line from the front to the back of the property. One of the issues though was, did this mean the lot line or like the actual boundary of the lot? So there was a lot of confusion about this. And then also with the security camera, you can put a security camera on your property, but where is the security camera facing? Is it capturing any part of one of the neighbors' yards or anything like that? So it was actually important for us to come up with this policy to kind of try and, add some additional parameters into, I guess, the lack of information that was provided in this section of the property code in this edition. So we did that with a couple of policies, but the issue is that this is one of those things that needs to be litigated, right? A lot of times when you have new rules that come out and you're not exactly sure, or it's vague, the actual parameters of these rules, then we need to make sure that, we're doing the best that we can to, make sure that our clients are in compliance with it. But there's going to be a situation that comes up where there's some disagreement on what it means, what a perimeter fence actually means. So and one of the things that we advised our clients on was that, we anticipate there being some sort of litigation involving these issues because it was just kind of vague. Now, I will tell you that there was a law or a bill that was introduced during this recent session that would have cleared up a lot of the issues that came up during or as we're applying the security measures amendment to the Texas Property Code. Unfortunately, that bill has not been, we're just not sure what Governor Abbott's going to do with that one. At this point, there are some talks about him calling a fifth special session to address this bill that I'm talking about that would clear up some of these things, but we're just not sure when that will be. And we're not sure how that plays into the governor's current agenda related to there's some other things that he's dealing with right now that he's, kind of put this on the back burner. But it's important because we need to kind of figure out, what this means and how to apply it properly, right? So as I mentioned, the association could potentially regulate certain things, but, we weren't necessarily completely sure what they could regulate. So again, with the fencing thing, right, I talked about whether or not what perimeter actually meant, but then also there's no specifics in that section about the type of fencing that the owner would be allowed to install. And there's no real information about, the location of the security camera. Just make sure that it's not on anybody else's private property. So we kind of had to include other things that we thought was type, right? So if you think about type, you're thinking about like the material that's used for the fence, but does that necessarily cover the height of the fence? Does that necessarily cover, any other thing related to the fence? And we're not sure. So we add some things into the policy and we kind of see, how it plays out. But we want to still make sure that the association is not at a complete and total loss with how it can regulate these things, because we don't want homeowners to just kind of like do whatever they want to, because that kind of defeats the whole purpose of living in a community or a property owners association, right? So hopefully we'll get some sort of resolution to, more clear information about the security measures, maybe before the end of this year. We're not sure. But again, this is something that has been providing kind of a headache to property owners association, especially the attorneys just trying to figure out how to handle this. All right, so there were some other changes under section 209 of the Texas Property Code, and it dealt with management certificates and collection policies. So with management certificates, I'll talk about those first. First of all, a management certificate is essentially the document that the association has to provide during the sale of a property. And what it does is provides all of the subdivision information. It lets a homeowner know, or a potential homeowner know, what the amount of the assessments is and the frequency with which they have to pay them. Lets them know that there are certain restrictions in place and points them in the direction of where those restrictions can be located. And, it'll let them know certain information about the subdivision that would either, make or break the sale of the home, right? But during the 87th session, there were certain amendments that are added things to what is required in the management certificate. Now, in addition to previously, the only requirement for a management certificate was for it to be filed in the real property records of the county where the property was located. But now, in addition to that, the management certificate has to also be filed with the Texas Real Estate Commission. And it needs to be filed. So if you file it in the real property records, it has to be filed no later than 7 days later with TREC as well. Now, there's also a little fee that's associated with that, and TREC has a whole system that's set up in order for the management certificates to be filed there as well. And the idea behind this is so that homeowners or potential homeowners can locate this information a little bit more readily. But there is some liability that's associated with failing to record the management certificate. You got to make sure it's filed there, because if the association doesn't, then there might be some monetary liability that's associated with that. So that is a new requirement by the 87th legislative session. Now, here's some of the information that should be included in a management certificate. Of course, you want to have the name of the subdivision and the name of the association, but also the recording data for the declaration, as I mentioned, contact information for the association. And if there's a website, which there actually should be, because section 207 of the property code requires a website now, the actual web address, so that a homeowner or potential homeowner can locate those dedicatory instruments. And then if there is a transfer fee associated with the property, so the transfer fee is whatever amount the association charges for basically the sale of the property, that needs to be listed on there. And then any other information that the association considers appropriate. So any other fees that might be associated with the sale or the purchase of a property, and anything else, that kind of information should go on the management certificate. It's important to do that because it's required by the property code, but also, as I mentioned, there could be some liability for failing to include this information and failing to record it in the proper locations. Now, I mentioned earlier that the association generally has the ability to charge assessments, and it is the personal obligation of the homeowner to pay these assessments. Now, assessments go towards certain things that, pay for amenities, they pay bills that are related, pay for any damages that are related to the association, repairs, things like that. So think about if your community has like a pool or something like that, and there has to be some pool maintenance, or if there's a guarded entry, that guard has to be paid and things like that. So that is what your assessments generally go to, right? If a homeowner fails to pay their assessments, then the association generally also has the ability to go out and collect those past due assessments. And then they're able to do that through a lien that is created by the association's declaration. And I would say probably 95% of the time, the association is given or granted the authority to foreclose on properties if they are able to collect those past due assessments. Now, because the association has this ability to go out and collect past due assessments, then the property code requires that there is a collection policy on file so that homeowners know specifically what the process is for collection. And so it's not a surprise to someone. So generally, and actually the property code provides a process and provides certain notice requirements in order for association to actually collect the assessments, but homeowners won't know what those are unless you put them out in some sort of policy. And I think another reason why we actually create these policies is because, while a homeowner is expected to have notice of a declaration and the contents of it, it's always better to have a policy that's been recorded. So a homeowner you can say, well, here's our policy. This is exactly what you need to know about the collection process, for example, and makes it a little bit easier, puts it in bite-sized information so that a homeowner doesn't have to kind of comb through, pages and pages of a declaration to figure out what the policy is. So generally, there are detailed standards for the association's collection process. And again, it focuses on assessment delinquency. And certain things that you need to know in order to actually create this policy is whether the association charges their assessments annually or monthly. And generally with single family homes, it's annual. A lot of times with condominiums, it's monthly. You need to know what the due date is for assessments. And generally the association can charge interest for late assessments. So you need to know what that interest rate is and when you should start to calculate the interest. And then also if the association has the authority to add late charges for unpaid assessments, including costs, attorney's fees, and expenses. So all of this information needs to be included in the collection policy, right? So everyone is fully aware of it. It should also put forth any procedure that the association will take if a homeowner fails or refuses to pay their assessments. And prior to the 87th legislation, the homeowner had like 30 days to respond from the date of a default notice. Well, that amount of time has changed to 45 days now. So a homeowner generally will be sent out a notice that says, hey, we didn't receive your assessments for 2023, for example, and you have 45 days to actually pay those. There's also certain requirements that you have to put in these sorts of notices. For example, you have to let the homeowner know that they have the opportunity to enter into a payment agreement if they choose to do so, or that they might be able to request a hearing with the board to kind of explain why they haven't been able to pay their assessments if they choose to do so, and other requirements. But all of these things, which are allowed for by the Texas Property Code, need to be contained in this policy as well. So it's easy for homeowners to know exactly what rights they have, so there's no confusion. So those are the ones that came out in 2001 after the 87th legislation for single family communities. So now we'll talk a little bit about condominiums. And the changes that came out of that session for condominiums related to open records production policy, records retention policy, and then a responsibility matrix, which I will explain in just a second. Keep in mind, Chapter 82 relates to condominium communities or condominium property owners associations. So there was already a requirement in Chapter 209, which relates to single family, to have an open records production policy. But now Chapter 82 associations are also required to retain certain financial and association records. And they are now required to make those records available for examination and production at their registered office for homeowners. So this essentially mirrors the language of a section that's already in Chapter 209. And part of the reason for this, I think, is because the legislature wanted to make sure that homeowners had the ability to go in and inspect financial records and other association records to kind of, if they so choose, to keep up with how the association may be spending their money, to make sure that it's, maintaining good financial practices and maintaining a good record of what the association has been doing, right? So some of the things are like bank statements, the association should keep those on file so that a homeowner can go in and take a look at those if they want to. And not only just go in and review these documents or examine these documents, but they can request copies of the documents as well for their own personal records. Now, this is not something that everybody would choose to do, but there are some people who might be interested in how the association is spending its money or like the financial health of the association to make sure that it can pay for things such as repairs or maintenance if necessary. And also, financial records are really important now more than ever because the lending practices have changed. So, if an association is not financially healthy, then there might be a situation where a lending company will not offer, a loan or a mortgage to a homeowner who's looking for assistance, related to one of these condominiums to purchase a condominium because they believe that the association won't be able to pay for certain things in the future. They don't have enough in their reserve account, right? So that means that, there's been a huge kind of debacle with like Fannie Mae and Freddie Mac where they're not offering lending to associations who can't keep up with their maintenance. So it's important to have these financial records on hand so that a homeowner knows, can my association keep up its maintenance? Can it, pay for certain things? Because if not, then that might present a problem. But with regards to a policy, of course, a policy needs to make sure that it sets forth what these rules are and how the association will maintain these records, and then even for how long, because that's important. Sometimes we get requests for production and discovery when we're dealing with litigation that, ask for records that go back 10 years or something like that. But if an association is only required to maintain records for 5 years, then of course you can't, create records that don't exist to answer discovery. So, a response to discovery in that situation would be, well, we don't have records going back to 10 years, but we do for 5. And here's the policy that shows that that's all that we were required to maintain. So we'll keep that in mind. All right, so this kind of goes into a little bit about how long the association retains its records. So they are now required by the property code, and I'm talking about condominium associations specifically, to adopt and record a records retention policy. Now, I want to also mention that a lot of the times when the property code is specific about adopting and recording policies like this, one of the reasons why they do that is one, to make sure that, there is constructive notice of all of the rules and regulations related to this, whatever community that you're buying into. But also with regards to like the collection policy, for example, the property code is very specific that if there is no collection policy on file, then an association cannot seek attorney's fees for enforcement of, past due assessments, right? Enforcement of the declaration with regards to past due assessments. So in order for the association to be able to seek reimbursement of its costs, its fees, and things like that, then these policies absolutely have to be put in place. And of course, there's also a provision in the property code that if certain documents, which are called dedicatory instruments, which a policy is a dedicatory instrument, it's not effective unless it's recorded in the real property records. So it's really important to make sure that's done. But back to the records retention policy. Okay, so condominiums are required to have these now. The policy has to describe the documents that are retained by the association. So really the open records policy that I mentioned before and the records retention policy that we're talking about now kind of go hand in hand with each other, because the records retention policy is going to list all of the documents that the open records policy has too, right? And so at the very least, the policy has to make sure that it has all the dedicatory instruments. So that includes certificate of formation, bylaws, restrictive covenants, amendments, and all of those things. And those have to be retained permanently. And so then we also talk about the financial books and records. Those have to be on file for at least 7 years. Records of current homeowners, they're their homeowner accounts have to be retained for 5 years. And if the association has entered into any contracts that have more than 1 year, the term of the contract is more than 1 year, those have to be retained. Generally, the association's bylaws require that they take minutes of their board meetings. So those have to be maintained, and then tax returns and audit records have to be maintained for 7 years too. So these amounts of time are mirrored by the section in Chapter 209 of the Property Code. So they're exactly the same, but we just they're here for, you know, a reason, obviously, right? So, you know, if a homeowner wants to go back and look at the association's financial books and records for 7 years, we should have those on file because we have this property code requirement that's making us do that, right? So this would make it easy too, because a lot of times when we're in litigation, as I mentioned before, you know, people will ask for certain association records that are not on this list. And then if they're not on this list, then the association might have them, but they're not required to maintain them or retain them. And so if they're not, then, you know, it's an easy answer to the discovery request, which basically is just like, we're not required to retain these, and we don't, and we haven't. And so we don't have any of those documents that you're requesting on file. But these are the ones we do have, right? Numbers 1 through 6. All right, so another really important thing with condominiums is a lot of times if you are a condo owner, then there are certain responsibilities that are yours, and there are certain responsibilities that are the association's when it comes to maintenance. So it is important to have a maintenance responsibility matrix, so it is very clear to homeowners who is responsible for what type of maintenance, right? So for a condominium, generally the unit owner is responsible for maintenance of anything inside the unit, and the association is responsible for maintenance of things outside of the unit. But there are certain nuances, and it could be different for every condominium that you might buy into. So obviously, because there might be some confusion, this is a recurring issue, you know, and it can vary, again, like I mentioned, according to what condominium that you're living in. And so this is, when we're creating these responsibility matrices, you have to think about, there might be some responsibilities in one document, and there might be some in a different document. And then there might be some maintenance requirements that are in the property code or in other Texas statutes. So in order to create this matrix, we have to make sure that we review all of the governing documents for the association. And then we also have to review all of the statutes to make sure that we're capturing all of the appropriate maintenance responsibility. Now, as I mentioned, the association is generally responsible for things outside the unit, which is called the common elements. And unit owners are responsible for things inside the unit, but that can vary depending on what type of maintenance it is, and then who might be responsible for whatever damage created the need for the maintenance, right? So that's why a maintenance matrix is really important. And then also sometimes you might want to include in the maintenance matrix the insurance obligations, because that can be different for condo owners. If there is any liability assigned in the declaration for guests or tenants or even pets, if pets are allowed in the condominium, anything that you think is necessary that has anything to do with the maintenance responsibility should go in the matrix, so that it's really easy for people to kind of go and reference that matrix and figure out who is responsible for what. Now, keeping in mind that there could also still be some sort of, you know, confusion about whose responsibility it is to, you know, maintain or repair damages that came from like a flood, a leak, a water leak in the unit or something like that. But a lot of times the declaration will kind of point to whose responsibility it might be. And then you kind of have to infer from the, you know, the contents of all the documents that you look at, you know, who should be responsible to handle that. So it's important to kind of keep this as a foundation for who's responsible for what, right? All right, so I mentioned also, I wanted to talk a little bit about resale certificates. So resale certificates are important when it comes to the sale of the property again, right? For single family properties, if you look in Chapter 207 of the Property Code, it talks about all of the different things that should be listed on the resale certificate, which I'll get into in just a minute. But also, if there is a request for a resale certificate, then the association has to deliver the resale certificate along with the restrictions, bylaws, and rules and all of that within 10 days after the request is received. And it needs to be prepared at least 60 days before the date it's delivered. So that means that if you have a resale certificate just kind of sitting around, that is not sufficient because it expires generally every 60 days. So that means the management company or the association who is responsible for creating this resale certificate has to make sure that it is created within 60 days of the request, or 60 days of the delivery date, excuse me. So I'm not going to go through all of these, and I don't expect for you to read all of this because it's kind of small, but these are all of the requirements that are related to single family communities, all of the things that have to go onto the resale certificate. The frequency of any regular assessments, any unpaid amount on the owner account that's related to the property that we're dealing with, capital expenditures, reserves, the association's operating budget, that's really important. Anything on the conditions on the property that are violations of the restrictions, that kind of thing needs to be included in the resale certificate. And again, the contact information for the association's managing agent, any liens that might be on the property, and statement of all the fees associated with transfer of ownership. So resale certificates are important, and they are a requirement by Section 207 of the Property Code. So that means that we got to make sure that those are done. And this is something that was kind of updated in the legislative session in 2021 that we're talking about too. Now, as you can see, these are the ones that I just talked about are for single family. These ones are for condominiums. There's a few less requirements, but nonetheless, there is a resale certificate required for the sale of condominiums. And I would argue that it's even more important to make sure you have all of this information correct for the condos, because there could be other issues that come up with the sale of condominium units, things that are not, or that are unique to condominiums that may not be necessary to kind of disclose if you're talking about single families. All right, so in conclusion, essentially, right, we're always trying to make sure that we're staying up to date with laws that affect POAs. And actually, like, for example, this year we're dealing with the Corporate Transparency Act, which a lot of you might have heard about. And you may not think that that is something that is related to property owners associations, but associations are nonprofit organizations or nonprofit communities, right? And so that is something that is required. We're going to have all of our clients report to according to the Corporate Transparency Act. So now we're trying to figure out like how we're going to kind of tackle that. It's kind of a huge task, right? Because if we have so many clients, we have to make sure that all of them understand that they need to report. So the laws are continuing to change, and we have to kind of stay on top of those things, because while they're changing, not only are they different, right, but they're becoming more intricate and demanding. There are also influences from, realtors or, local and state and federal government. So all of these things are kind of, seeping into the association's ability to self-govern or self-regulate. And we are trying to make sure that that actually stays intact as much as possible. So, we have to kind of stay abreast of all of the changes as much as we possibly can. And it's really important for us to stay well informed. So not only are we looking at, legislator here in Texas, but we're looking at like national changes, federal things like that Corporate Transparency Act that I was talking about, because things are constantly changing. So we have to make sure that we stay on top of it, so our clients can stay on top of it as well, because that's what they're paying us to do, right? But yeah, that kind of concludes the information about forms. And now I have time for any questions if you guys have any.
Yeah, please feel free to unmute if you have any.
Noel, can I ask a question? Does TREC have a standard resale certificate form that they're requiring POAs to fill out, or is it just, I've seen both. I've seen them a uniform one, and then I've seen some of these title companies have created, and that's kind of been confusing for my treasurer to figure out, proper protocol on that.
Yeah, I don't think that there's a specific form necessarily, as long as you have all of the information on there that they're requiring for the management certificate. Of course, we use a certain type of form, just, kind of going according to what the statute requires. But I'm not sure if TREC has put out one or not, and generally TREC has forms, right? So maybe they'll do that sometime in the future. But at this point, we've just been using what our form is.
Awesome. Thank you.
Yep. Anything else? I don't see any questions in the chat, Elena, so I think that we might be done.
Am I done? Okay. All right. Does anyone have any questions?
Oh, I see
Free to-
one.
Okay.
When did they start needing to record with Trek? So that requirement actually started in 2022, like at the beginning of the year. But there were certain things that there were certain exceptions, right? So if you had not previously recorded a management certificate, then you had to do it within a shorter amount of time. But if you already had one and it needed to be updated, then you could go ahead, and I think that gave you like another 3 months, 3 to 6 months. I'm not exactly sure what the requirements were, but this was a requirement that started back in 2022.
Oh. Do they foresee any other changes to, I guess, those statutes that you mentioned?
Yeah,
Especially.
so
Mhm.
this year, so the legislative session, the 88th, was in 2023. There has been quite a few laws related to property owners associations that we were anticipating being reviewed and being signed into law back then. But that hasn't happened because the governor has not yet reviewed them. Because of, there are certain things that are going on with like education and property taxes and things of that nature that is preventing him from looking at everything else. So there is word on the street that there will be a 5th special session where there will be additional review of pending bills, but we don't know when that's going to happen. So we're just kind of standing by right now.
Gotcha. Okay. All right. And I have posted today's CLE code in the chat room. So please review the chat room if you would like to receive a CLE certificate. Then I have another question for you, Ms. Hicks. Also, I was just thinking about just occurred to me about immigration status. Have they said anything about that in relationship to property owner associations?
That has not been something that's come up, not just yet. But that is a hot topic here in Texas. And so, I would not be surprised if that was something that did come up, but for right now, that's not an issue.
Okay. All right. Gotcha. Okay. I was wondering about that because I heard, I guess, chatter about uh, different countries buying up property, and owning it. And so I wondered whether or not they had anything in place. I know political parties were discussing it or using it as a platform, so to speak.
Yeah.
So I just wondered if they had put anything in place.
Well, that's something that they would have to be really careful about because there is, we have to be concerned about the FHA and making sure that we are not doing any sort of discriminating when it comes to housing provider. Right. And a community association is a housing provider as defined by the FHA. And I think that we have another presentation where I'll get into a little bit more about, discrimination from housing providers under the FHA, but that's something that they would have to really steer very, away from, actually, I think, because they don't want, discrimination claims coming up.
Gotcha. Okay. All right. Good to know. Good to know. All right. I hope everyone has seen the code in the chat room. If you have any other questions or anything, feel free to unmute and speak directly to Ms. Hicks. Yeah. And thank you so much, Ms. Hicks, for this presentation. It was, as usual, very informative. And she does have another CLE coming up on February 5th that you all can register for, called Overcoming Racism in today's property owner associations.
So that one is going to be actually, hopefully a lot of people come to that one because that one was a big topic that we did right after the George Floyd incident. We realized that there were a lot of, instances of racism popping up in community associations. So I did a paper about it, and it was something that was received differently in different places, as you can imagine. But it's an important topic. So I want to make sure that you guys please come back for that one because it's one I'm really passionate about.
Yes. Yes. Yeah. I think so too.
And Ms. Hicks, I do have a question. I'm very much looking forward to February 5th.
Sure.
So I'm kind of circling back to the display of religious articles
Mhm.
at your home. And I'm just curious because like with the, I mean, it says if any, if I remember, it says any object that might be offensive to somebody like a passerby. And that seems a little broad.
It does.
And I'm like, have you seen any instances where people try to take advantage of that? I know like, we've seen a rise in, anti-Semitism and, our Palestinian friends have been getting backlash as well. I mean, have you seen anything like that?
Yeah, I've seen quite a bit of that actually, unfortunately, and there was a lot of that when there was a peak of anti-Semitism instances happening, and a lot of times people are using that rule to just kind of put up whatever they want to and saying that, oh, this is because of my religion, just like a post, or they would say like Christians for Trump or something like that is a sign that I remember. And people were saying, this is my religion. It's not political. It's about my religion, and so I can keep this. There was argument with the association about keeping that. But the passerby, offensive to a passerby, is something that's extremely subjective, right? So it's difficult to kind of make that argument. But the association has other ways to kind of get around certain things, right? So if we're talking about a sign, for example, then sometimes there are, the association has certain rules related to signs, right? And there's even some things in the property code related to like the display of signs. And so we could say, okay, we understand that this might be part of your religious beliefs or your religious practices, but the association doesn't allow signs that are bigger than like a 4x6 or something like that. So you got to take it out. But we do have to be careful about this, right? We have to be very, this is a delicate situation. And this section is not making it easy for associations because, like I said in the beginning, if someone wanted to go out and erect a, 6-foot cross, they could do that. So we just have to find other ways for the association to regulate it. And if there isn't, then, you have to make sure that you're weighing, what might violate the law versus this delicate conversation. So it's been difficult, because we have to handle this one with kid gloves, especially with all the stuff that's going on right now.
Thank you.
Yeah.
Yes. It is interesting what new discussions come up as a result of everything that's going on.
Absolutely. And like I said, I know a lot of times, even before I started practicing this type of law, I never imagined some of the issues that I would have to deal with. And so I know that these are things that just don't cross people's minds, right? Because maybe you don't live in a community association, but even if you do, people are just like going to work and coming home and minding their business, but these things come up. And this is an industry, even during like the COVID-19 pandemic, this is an industry where we never had like a lull in work, or, everything was still kind of popping off because it actually was worse during the pandemic because people were at home looking at other people's properties and like reporting violations and stuff like that. And then also in general, we're just seeing like a lack of civility amongst neighbors and that kind of thing. So it's making it so we have a lot of work to do.
I'm curious. So I was reading an article the other day. Tyler Perry, one of the ladies, senior citizens that she was trying to help, was 94. She passed away. Now this is I think they're in Georgia, but any event, she was in a fight with some land developers who wanted her land, and she had that property since her Civil War era, whatever, and they were trying to take the property from her, and so they sued her to take that property. And so I was wondering, have we ever had anything like that here?
If you are in here in Houston, if you're familiar with the Third Ward area where Texas Southern University and U of H are located, and they built the Metro Rail right through that area. Basically what they used was eminent domain for them to be able to take those properties, even if people didn't really want to sell them, they took those properties so they could build the rail right there. So that is definitely something that happens. It happens more than you would think, but a lot of times there's nothing that the homeowner can do if they want to, take that property and use it for something like the Metro Rail. I think the only thing that might be able to save a property like that is if it has some sort of historical designation or something like that. But even then, if the government or the local or federal government is coming in and saying that they need that property for something that would benefit, the entire city or the entire state, then that would probably outweigh that person's desire to keep the property, and they still might have to give it up, but they would have to be compensated fairly. So then a court would step in and say what the fair compensation is for that property owner.
Okay.
That's,
Wow. So
I went to the University of Houston. I stayed on campus in the Moody Towers, and it's like runs right by the Moody Towers.
Yep, it sure does. I live in that neighborhood, so you could see the signs that were being put up, to kind of notify that they have requirements that they have to put up certain notices to let the community know what their intentions are. And you could actually kind of see how, like, one by one the properties were disappearing, and you could tell the ones that were holding out because they didn't want to let go of their properties. But I'm assuming, I didn't follow that litigation all the way, but I'm assuming that they were fairly compensated for giving up the property.
Hope so.
Wow.
Yeah.
So just let me give you Cougar Paw. Go Cougs. Still crying over the loss last night. That's all right.
Yeah. So it makes me also curious about, because not only are you fighting potentially the federal government, local, state, and federal, but also the squatters or people that are just can take your property just because they want it, by fraudulently going and filing something in the deed records.
So, okay, that happens too, right? Anybody can go file a deed in the real property records, right?
Mhm.
But I did have a situation not too long ago where a homeowner had fallen behind on her assessments, and you could tell that she wasn't maintaining the property, but turns out she didn't have any family and she needed care. So the city stepped in and they took possession of her. There was a guardianship opened, and someone needed to help her out. But that means that they took her out of her home and they put her under the county's care, but then people came in and squatted in her property. So the association then had to go through legal process to try to get those people out of her property because they were creating a dangerous situation there. They were, leaving trash everywhere, and there was some criminal or drug activity going on. So that kind of thing happens too, where we have to step in, and then, the association ends up having to pay for the litigation to try to get that property back into either their possession or someone else's, but at least to get those people out of the property because they don't own it.
Mm. Wow. I have almost a similar situation with a friend of mine where her aunt has dementia, and they've removed her from the home, but the home is vacant now. So
Right.
may need to bring that to her attention.
Yeah. And I mean, honestly, it would be better for her to either take possession of that home or put it on the market. Because if she doesn't, then it's open to people who, if someone sees it, I don't know if you guys saw this, there was a news story about this where this man went in and just squatted in this home, and the neighbors were complaining about it. And he was like, well, y'all can't put me out because I'm here now. And he was trying to use adverse possession in order to take over ownership of the property. But you probably know with adverse possession, there's a certain amount of years that have to pass. And it's like 5, 10, or 20. And none of those time periods had actually passed, but he was sitting there, and they can't physically remove him unless there's some sort of court order or something like that. The police won't do that.
Wow. They just get away with things.
Sometimes people are just savvy enough to be able to, hold out for long enough. And then that ends up costing the association a lot of money too. And in turn, costing homeowners a lot of money, right? Because they're having to pay for the legal fees to be able to correct the situation because it's a nuisance in their community.
Right. Well, I'm seeing it more and more. Like, hey, I'm reading headlines across the country where you have folks that either they were the legal owners, but it got foreclosed on and they just refused to leave. And then they kept filing motions to basically make the people go away, who were trying to take possession of the property. Then you have the people that purchased the property that can't take possession of the property. Just a mess.
Yeah.
But it's just hard on everyone. Yes. But I just don't get how it can go for years and years.
I'll tell you how. I had a situation just like this. My mom's a realtor, and there was she had a client, and someone was squatting in her client's property. So they had to file an eviction. Well, the court granted the eviction, but then the lady appealed it. So that means it went to another court and there was another time period, right, that they had to wait in order to be able to get to the court. Well, then they go to a different court. That court orders that this lady has to be put out, but then she filed for public assistance under the COVID-19. There was some sort of assistance, right? So then the court had to, review that. And then they determined that she still needed to get out. Then she filed for bankruptcy, which puts in an automatic stay and makes it so nobody can do anything to her. But unfortunately, she didn't know like the bankruptcy rules well enough to know that there are certain things that you have to do when you file bankruptcy. But all of that I'm talking about extended the time period like almost a year.
Wow. That is amazing.
Yeah, she knew just enough to keep herself in that house for about a year after we started the eviction process.
That's crazy. Did it happen during COVID or?
It was like right after COVID, like
Okay.
when COVID started kind of to die down a little bit.
Yeah.
Right. But there was still like the public assistance with regards to housing available. There were certain things that people could do to keep themselves from getting evicted. Right. So she was looking into that kind of thing. But then, so someone's asking what was the bankruptcy glitch that got her removed. There is a certain certificate that you have to file along with a bankruptcy case that shows that I think that you took some sort of education related to the bankruptcy, and she didn't do that. So that certificate was not filed along with the filing to open the bankruptcy case. And so the court eventually, they gave her an opportunity to take the course. She didn't do it. So they ended up kicking the case out. But of course, that entire time there was a stay there. So we couldn't do anything until the court eventually just kicked the case out.
Wow. It's just interesting, all these legal loopholes, if you will.
And when I do these presentations, when I do them for the state bar, or whatever, people are always like, really? And I'm like, yeah, this is, it's crazy. And especially this is such a niche, type of law. People don't really understand like this. It can get crazy. It's the Wild Wild West out here.
That's what it seems like. Yes.
Yeah.
It's a great description of it. Okay. All right. Well, Billy Hart has posted a news article with Texas Monthly. He posted a link in the chat room. So if you all would like to read that article, please click on it.
The only thing I will say is that you may have to log in, but if you want a copy, it's actually exactly what you're talking about regarding just someone coming in, taking over their deed, taking over their property. Attorneys got it's a long article, but it's eye-opening.
Wow.
It's same page not found, Billy, but I think I know what you're talking about, and I think it's the same case that I was mentioning.
Wow. That is so interesting. Yes. Well, thank you. Thank you,
Yeah,
Billy.
sure.
And also thank you, Ms. Hicks. Okay, I think most people have got the CLE code. Also, the question is, can we get a copy of the PowerPoint? Is it okay to send your PowerPoint? Okay.
Do you need me to send you a copy of it?
Yes, please.
Yeah, sure, I'll do that.
Send it to me and I'll get it out to our members who request it. So if you would like a copy of the PowerPoint, please include that with your email and I will get that over to you. And thanks again, everybody, for joining us today. Thank you again for a wonderful presentation, Ms. Hicks. And again, please check our calendar for other upcoming presentations by Ms. Hicks and other folks on our website, dallasparalegals.org.
All right, thank you guys. Have a great one.
Yes, thank you.